Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
So we have done this in the past also. This question, this is nothing new to us. So we need not spend too much time on this. But just to recapitulate, we have, as you know, we have a presidential system of government, prime ministerial system of government. Sorry, presidential system, prime ministerial system of government, in which the cabinet, headed by the chief minister or headed by the prime minister at the center, wields the real power. Now, governor, as per the Sarkaria Commission report, is supposed to be the mentor and the friend and the advisor and philosopher and whatnot of the state government. But it seems when there are different uh, ideological, different parties with different ideological backings and in the center and in the state, then usually the governance is not very smooth. Now this trend has started, and the governors of some of the states are a case in point. And in this kind of scenario, the Supreme Court uh, has laid down a timeline for the governors to act on the bills which are presented. In its judgment, also went ahead and fixed the timeline for the president. So, and that is criticized by some on the grounds that it is a case of judicial overreach. So, this is what primarily the article talks about. And if there are problems, then you can, if there are doubts or differences on whether or not a matter should be, matter raises a concern about some constitutional provisions uh, on which the state should or not legislate, then the apex court has indicated that you should approach the Supreme Court for its advice under Article 143, which is the advisory jurisdiction of the Supreme Court. We have also seen that a governor cannot approach. In the previous article on the same issue, we have seen that a governor it does not have the power. The high courts don't have the power. Only the Supreme Court has the federal court. The Supreme Court only has the power to give advisory opinions. Right? These things we have seen in the past also on the past article, which we have discussed on the same topic. Right? So let us come to the questions. Yes. So this 16th question, there is a problem with this, so we will not stay on this. 17th question, Governor of State, why refers a controversial education bill to the President? 7 months later, the state receives no decision or explanation from the President's office. What is the likely constitutional outcome in this case? So, controversial education reform bill 7 months later receives no decision or explanation from President's office. So we know that in this case, what is to be done? In this case, the president has to basically give reasons for this thing. So the clear-cut case is that the educational bill was referred to the president, and it was first reserved by the governor for consideration of the president. The president kept sleeping on it. Now, what is the new dispensation? If the time is exceeded, then the president has to give the reasons as to why it took longer time. And those reasons, what is the utility of those reasons? What is the utility of the reasons? The reasons basically streamline the process and bring accountability into it. Because if the reasons are not there, then no further course of action may occur. If the reasons are absurd, then once again you can approach the courts for suitable directions. So reasons bring accountability. That is the that is why the reasons are required. Reasons insisted upon. President is immune from time-bound directives. Time-bound directives. President is immune. Yes, president is personally immune, but the central government is not immune, right? Governor's delay nullifies the referral. No, the referral cannot be nullified. That is not written in the paragraph. President's office must now provide written. Yes, after the judgment, they have to provide the written reasons as to what is the cause for delay beyond 90 days. State must wait indefinitely. That is not what is there in the paragraph. Come to question number 18. State, is that clear to you? 17? 17 is done?
Yes, sir.
It's done. A state legislature passes a controversial land acquisition bill. Civil society groups approach the High Court seeking a pre-enactment review. Now you know that you can't approach the High Court, right? Presidential reference has to be only in the Supreme Court. It can't be in the High Court, and only by the president. It can't be by the governor, right? So I need not. High Court may not opine on the constitutionality. High Court cannot opine. High Court doesn't have the jurisdiction to opine. Then we come to a governor reserves all state bills. Now you can't do that indiscriminately. You are being arbitrary. Governor's blanket referral is erroneous, undermines federalism. You can't do that. Whatever comes, you keep it on your table and keep sleeping on it. That is not the constitutional scheme. It's once in a while, if in a in a term one or two bills are maybe objectionable, then those bills may be referred. It is not that lock, stock, and barrel all bills reserve or send back or refer to the president. No, this is not done. This way, how will you run governance if this kind of thing comes along? Now, please come to the next one, legal reasoning. Uh, Prakash, this thing on adoption. Screen is flickering. The problem is this. Are you seeing? Are you facing the same problem? Is there
No,
clarity?
sir.
You are not facing the same problem. But it is local issue. I'll after the class I'll get in touch with the. All right. Tell me what is there in this.
This talks about the adoption process in India under the Juvenile Justice Yes, and Protection of Children Act. The legal dispute over the adoption leave and key court ruling on adoption eligibility. Sikara many child adoptions and prospective parents must register online, undergo a home study, and are placed on a waiting list. Issue in the adoption process, the delay in matching children to parents and adoption eligibility restriction create a concern. There is a case of 46-year-old woman from IIM Raipur was denied 180 days adoption leave for adopting a newborn. And she challenged this in court, arguing that she is entitled to leave under the Central Civil Service Leave Rule 1972. And I, IIM Raipur argued that its HR policy did not provide adoption leave, and adoption leave is a constitutional right under the Article 14, 15, and 21. And if a woman workforce participation is a constitutional entitlement, and fundamental right can be enforced even against the private institution. The
Yes.
prospective adoptive parents do not have fundamental right to adopt, and the parents with two biological children can adopt only special needs or hard to place children under the adoption rule 2022, and the court upheld the application for new adoption rules, and children with disabilities, emotional disturbance, high risk disease, age limitations, and normal children under the 5 or not place adoption within 60 days are come in the hard to place definition. And there are several prospective parents against the retrospective application retrospective application of 2022 rule. They argued it violated Article 14 and the court dismissed their court, uh, court dismissed their petition, starting adoption eligibility criteria are policy decision, not individual. And parent with two disabled children challenged the color detection their application to adopt a normal child, and the Bombay High Court ruled in their favor, ordering the reconsideration within 6 weeks. Adoption eligibility focus on the child welfare, not parental preference, and the court emphasized the flexibility in the cases of disabled children. And regulation must balance bureaucratic rule with special circumstances.
So this article says that the under the Juvenile Justice, Care and Protection of Children Act, people who want to adopt a child, they must register with the Central Adoption Resource Authority and through an online system. And after registration, a home study is done to check if the parents are suitable, and then they are added to a waiting list. And as of now, there are over 35,000 prospective parents and only around 2,400 children available for adoption, and many of them are with special needs. And uh, delays in the adoption process have been in concern. And one major issue involved adoption leave, and a woman was working at IIM Raipur who adopted a newborn baby, and she was denied 180 days of adoption leave because the institute's policy did not allow it. And she went to the High Court, which ruled in her favor, stating that the adoptee leave is a legal right and part of a women's constitutional protections. And in another matter, some parents with two biological children challenged the new 2022 adoption rules, which basically allowed them to adopt only special needs or hard to place children, not a normal child. And the court dismissed their petition, saying that there is no fundamental right to adopt any specific child, and that the rules were made for the welfare of the children only. However, in a different case, the Bombay High Court supported a couple with two disabled children who wanted to adopt a third normal child. The court said that their case was special, and the authorities should have considered it more carefully, and it allowed the couple's plea. Nothing that adoption rules do have room for relaxation in special situations. That's all from my side.
So this article is about the Juvenile Justice, Care and Protection of Children Act. Now, this act is basically about how people can adopt children and other processes regarding this. Now, if a couple wants to adopt a child, then they must first register themselves with the CARA, which is the Central Adoption Resource Authority, through its online portal. Afterwards, a home study will be conducted to assess whether the couple is suitable or not to raise a child. As per the CARA, there are over 35,000 registered parents, but only 2,440 children that are available for adoption, and many of them are special needs. So this has raised many delays in the process to ascertain whether the couple are eligible to raise these children properly or not. Now, in a case mentioned in the article, a 46-year-old woman who was an employee at the Indian Institute of Management, Raipur, had adopted a newborn in 23 and had applied for a 180-day leave under the Central Civil Services Law, Leave Rules 1972. Now, the IM had denied this and only offered a 60-day community leave as per its HR policy. Now, the woman had then filed a petition at the Chhattisgarh High Court. Afterwards, the HC had ruled in her favor, stating that the institute's silence on adoption leave must mean that central rules apply, and that adoption leave is not just a benefit, but a constitutional right according to Article 14. There's also been a rule change regarding adoption regulations. Now, the adoption regulations 2022 had replaced the 2017 regulations, which reduced the eligibility of couples with two or more children, and that these couples could only adopt special needs children or hard to place children. So
Yes.
now there was an exception to this rule where the Bombay High Court had in its ruling said that this in the case regarding a couple from Mumbai who had two disabled biological children wanted to adopt a third child, which was a normal child. Now the CARA had rejected this request based on the 22 rules, but after the petition, the Bombay High Court, the HC had ruled in their favor, stating that there should be flexibility in for special situations and that the couple's desire for a new hope was reasonable and humane. That's all from my side, sir.
Yes. So basically, this article, this article raises a few propositions. First proposition is that when the what happens when the institution's rules are silent? Then in that case, since the government is involved in establishment of the institution, the civil service rules will apply. Although the institution has autonomy, the government has granted it autonomy for purposes of excellence, the article says so. And from the state government interference in its internal affairs as well as from the union government's interference. Uh, the, the IMs have that kind of privileges. For that matter, all national institutes have that kind of privilege. Even National Law School has that kind of privilege. So they want minimum interference, maximum autonomy and accountability. That kind of arrangement they have worked out for the national institutes of importance. And here a case has arisen where the rules of the institution are silent. And the court has clarified that where the rules of the institution are silent, then the civil service rules of the central government would apply. This was as per this is provided in the um, there is this is provided in the 1972 rules, uh, where it says that central civil services rules are applicable where the institution's rules are silent, right? So that is one part of it. Then second part of it, of course, the court has also dealt with the 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 constitutional issues. Also, the court has opined on them. But the ratio decidendi of the case is basically that since there are civil service rules which are in operation, and since the institute's rules are not there, are absent, therefore the civil service rules will apply. The court has made several other observations as to uh, maternity leave being a matter of right and not a matter of discretion in the authority. So those kinds of things have been stated. Now, this article is a amalgamation of two articles on the same or related subjects. Therefore, I clubbed the two articles together and then put them into this. The second fact situation which is elaborated is which is taken from another source. Basically, it lays down the proposition that uh, uh, in matters of adoption, basically certain rules have to be followed. It's not that you approach an adoption agency and the agency says, "All right, I'll help you get a very intelligent child or the child with this kind of these kind of qualities and all that." It is not permitted. What is permitted is that the benefits or to the child come first and the choices of the parents come second. The public interest is in ensuring the welfare of the child. Therefore, they have this system wherein they would first want to place hard to place children or uh, children who have special needs. Those are the children they prefer for placement first, and they follow a sort of seriatim order in which they want to place the children. And you can't jump the queue. You can't do cherry picking. That kind of things are not possible. Uh, And then the court has also made an observation that there is no fundamental right to adopt. So that kind of thing is there. Article 21, Article 14, you can't build an argument based on. Just give me 1 minute. It has started what we call as the sandstorm has started. So let me close the windows of my office. Otherwise, everything will be under sand. Just give me 1 minute. So the court says that look, the welfare of the child is paramount, and we will give importance to the requirement of the child rather than the requirement of the parent. And then there are some passing observations on the delays that are there in inherent in the system. And then um, um, I think that's it. That is all that it says. Of course, it also talks about the if you have to. There is a mention in the article that earlier even couples with 4 children could take another child in adoption, but subsequently this number was brought down to 2. And in this case, interestingly, the court has directed the authority to use one of the rarely used provisions in the Act, which basically says that you can take a liberal view in special cases. And here the special case is that 2 children are already special needs children, therefore they wanted a third child, and which is denied by the authority. The High Court says that no, you have the power, you exercise your power and issues a direction to that effect. So this is what this article talks about. These are few of the propositions that the article talks about. Now let us go to the questions. Let us see how the questions shape up. Prakash and Nisha, I'm on question number 20. Prakash and Nisha, newly married couple, want to adopt a child. They approach a private adoption facilitator with a request for adoption of a child whom they have already identified. That is not permitted. That we have already discussed. That kind of thing is not permitted. Facilitator promises to find them a healthy child quickly. Whether the couple are entitled to adoption, they may be entitled to adoption. Yes, they are entitled to adopt because it is not written that they have more than 2 children, in which case that disentitlement would come into operation. But they can't adopt like this. You have to follow the procedure, and we have discussed what is the procedure. So number 1, you are in the queue. Number 2, you have to prioritize the needs of the needs of the children for placement rather than needs of the parents for obtaining the placement. So that kind of thing is there. So none of the above would be the correct answer, huh? Because the answer is couple may be granted the adoption of the preferred child. Preferences are not the rule. Couple has wait for their turn. Of course, they have to wait for their turn, but it is only half the answer. The question is whether they are entitled to adopt or not. That is the question. The couple has to get the adoption process approved by court. This is neither here nor there. This is a distractor. So none of the above would be the correct option. Please come to question number 21. Kamla, an employee at a private university. Now this is private university. That university is a public university. This is a private university. There the civil service rules apply. Here the civil services rules don't apply. Therefore, whatever is the rule of the university that will apply, and that rule may be contradictory to the rule of the university. Is that clear to you? Yes or no? That is a public body. This is a private body. So the private body rules would apply. All right. That may be different from the rules of the public body. Is that clear to you? Yes, no, indifferent.
Yes, sir.
Yes, very good. Then please come to the 22nd question. Suraj and Meena have 2 biological children. Apply for adoption of a third child. Now they have 2. They are applying for the third one. This is prohibited by the new regulations in 2022. They request an infant, but due to updated adoption, they are informed that they can't adopt a child. In a writ filed by the decide the couple, there is no entitlement because under the 2022 rules, they have reduced the number from 4 to 3 to 2. That is how the reduction has taken place. So there is no question of any adoption right vesting in them after the 2022 regulations have come into existence. Please come to question number 23. This is 100% correct, so I need not dwell on this. 24. Ravi and Anju applied to adopt a child under adoption regulation 2017. At that time, 4 were allowed. Their application is finalized and adoption is also granted. All right, now you see, adoption is granted. This makes a difference. Decision is taken. You are allowed to adopt. The letter is issued. Then, then they say they already have 2 children. Meanwhile, 22 regulations come into effect, limiting their options only to 2 children. The authority revokes their application. Now they say that no, no, now we will not allow. But the problem here is they challenge, arguing that the new, oh, here is that one. Where was I? I pressed something and it just disappeared. Now it has come back. All right. So, just 1 second. Yes, now it has come back. The authority revokes their application. They challenge this change, arguing that the new rule should not apply to pending applications, whether the application may be granted. Now you see, here their application is finalized and adoption is granted. Thereafter, the new rules are coming into existence. Please look at the date very carefully. Today my computer is gone berserk, completely berserk. It has gone wild, just continuously flickering and giving me a lot of jitters. That is all it is doing today. Just give me 1 minute. Too much nuisance. Just give me 1 second. Yes, now it has. Yes. So what I was saying is that the application has already been granted. Once the application is granted, once the decision has been taken, thereafter they can't say and turn around and say that look, a new rule and regulation has come into existence. Therefore, we will not allow it. That option is not available with them at present. Is that clear to you? Yes. So the application is already granted, finalized and granted. Everything is already done. Therefore, the right is already vested. The vested rights cannot be divested because this has been marked correct by 2 kids out of 3. Does that make sense to you? Do you appreciate the point? I'll spend some time on this.
Yes, sir.
The vested rights, once it is finalized, it is granted in your favor before the 2022 regulations come into force. Once the decision has been taken, the rights becomes vested. The right becomes vested in you. Then you cannot say that look, 2022 regulations will apply. Had the decision not been taken, you follow? Had the decision not been taken, the position would have been different. Then the application would have been pending. To the pending application, 2022 regulations would apply. But once the decision is taken, then how can you how can you turn turtle the decision which has been taken and apply the new regulation? The decision has already been taken under the old regulation and finalized also, adoption also granted. Then you won't be able to take this route, take this route of the new legislation which has come into existence, right? Could you hear what I was saying? Because my screen continuously flickers, it gives me a lot of annoyance, but I can't do anything about it. Did you hear what I was saying?
Yes, sir.
Were you hearing? All right, you are hearing. Very good. So now I think this is complete. This is complete. Now please come to the logical reason.
Passage talks about the stand for completely automatic public turning test to tell computers and human apart and designed to distinguish human from both, usually puzzles only human can solve, and introduced in early 2000s and to counter the automated boards that created a fake accounts, spam sites, and stole data. And it developed by Louis Vaughan and Manuel Blum, Nicholas J. Hopper, and John Langford, and first patent filed in 2003, and it initially relied on distort text challenges which would struggle to decode, and it prevent automated attack, attacks and protecting websites and user data, and used in account registrations, login system, and comment sections, financial transactions, and survey, and ensure only real user interact with online platforms, and it It is in 2009. It is reintroduced using a scan book text for verifications and digitalizations, and it's launched detecting human activity based on m- mouse movement, and it helps in businesses prevent bot intrusions and protect the financial and
Yes, yes,
e-commerce
please
sites
continue.
from
Please
fraud,
continue. Please continue.
and used in poll and survey to ensure the real human response, and accessibility concern for visually or hearing impaired users and annoying for mobile users for making interaction slower, and need to adapt to smarter AI and bots, and must become more user friendly and accessible and likely to be a part of large security ecosystem rather than standalone solution.
Yes.
So this article is basically about the capitalization of citizens' personal data. Now, this article begins with the digitization of medical records. So now, if you look at any clinic, private clinic, especially a private clinic, now you would notice that there's a lack of digitization when it comes to medical records. Now, this is despite policy initiatives like the Ayushman Bharat Digital Mission. So now the problem with this lack of digitalization is that this affects the healthcare innovation and other stuff like the pricing of insurance, research, and probably development of AI tools in the medical field. Now, the article frames this as not a as a lack of monetary value, as a lack of incentives to share the data. Neither the patients nor the doctors see any immediate value in this data that the patient has. So,
They
what the
started
article suggests is that
they started from the fourth one, fourth article.
so what this article proposes is that
Yes.
India should build a India should capitalize its medical data. It should build a citizen-centric data market where people can choose to share or sell their healthcare data, whether it be anonymous or publicized identity. Now, this should, in theory, encourage more clinics and hospitals to digitize. Now, this is compared to the models from US and the UK, where the patient's rights over their own data is restricted, which may benefit institutions but not the individuals, and that these models are unsuitable for the highly privatized and decentralized healthcare system that is in India. So, we should create a regulated free markets for the sharing of data, whether it be in the healthcare sector or any other sector, as such a initiative would boost India's economic productivity, since data is a very valuable resource in today's time.
India has a large population and fast-growing technology use, which means that the data created by its people is very valuable. And however, current its people is also very. However, current data policies in India don't clearly see the difference between data as identity and data as property, and all this confusion is holding back progress, especially in the health sector. And uh, most health data in India is not digitalized, and big hospitals have digital systems, and government hospitals have some basic digital tools. But many people go to small private clinics where there is no strong reason to create digital health records, and all this makes it hard for doctors to access past medical data, for insurers to set fair prices, and for researchers to study treatments or train AI tools. The government has tried to solve all these problems through the Ayushman Bharat Digital Mission, which lets citizens own and share their health records across hospitals. And this mission has tools like doctor and hospitals registries and consent system, but the main issue remains during a doctor visit, neither the patient nor doctor sees future value in storing the data. For data to be available, it must become valuable to the patients. And if citizens can share this data with commercial users, they will prefer clinics that follow proper digital systems. All this will also help doctors and support new businesses around health data. And uh, this article argues that India's policy should focus on giving citizens full control over their data, like property, which they can keep or sell. Western models like the US or UK don't work well in India because they either allow hospitals to profit or own the data, not patients. And India needs a citizen-first data system with strong privacy tools and clear rules so that people can benefit from their own medical data instead of just protecting it like a secret part of their identity. That's all from my side.
Yes. So basically, this is interesting article on the value of medical data and how we can incentivize the availability of such data. And then he compares the US and the other models, the UK model and the other models, and then arrives at a conclusion that this is highly desirable, and we must be able to um, uh, find out ways and means to do it. That's it. A very simple but very useful article. Let us now come to the questions. 73rd question. Based on author's arguments, which of the following true would reduce the decline in value of healthcare data in India? Reduce the value of decline in healthcare data in India. What does it mean? Means uh, increase the value of healthcare data, right? Two negatives make a positive. So it means increasing the value of healthcare data. Then what do you say to this? Large private health hospitals continue to dominate would reduce the decline of value in healthcare. So what is going to increase the value of healthcare data in India? Large private hospitals continue to dominate the healthcare data systems. Will that increase the value of data, medical data? What do you have to say? Will that increase the value of medical data? Presence of large private hospitals continue to dominate healthcare data systems. Will it increase the value of medical data? What do you have to say on this?
Dear students, GPS CLAT Academy at Gyanoday, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.